if a defendant is prosecuted and convicted by a special district attorney who doesn't satisfy the requirements of that office, can that be raised on appeal for the first time? To find out, you have to read People versus Callara, but it's 8 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Callara. The citation for this case is 2025, New York Slip Opinion 05739, published by the New York Court of Appeals on October 16th of 2025. The issue in this case is whether a special district attorney that fails to satisfy the residency requirement, is that a waivable defect, or is it a mode of proceedings error that does not have to be preserved for it to be raised and reversed on after the conviction? To understand and appreciate the context of this case, the helpful background to know is that there's a preservation of error issue, preservation of error doctrine under Criminal Procedure Law 470.05. Any issue that the defendant wants to raise on appeal has to be preserved at the time when it's raised, when the issue is raised first at trial or in the underlying matter. So under 470.05, you actually have to make an objection at a time when it can be corrected or addressed by the court. And if you fail to preserve the error, let's say evidence comes in and there's no objection made, you're not allowed, after the conviction's over, to then make an appeal based upon that unpreserved error. There are exceptions to that preservation of error requirement. One of those exceptions is called a mode of proceedings error. A mode of proceedings error is an error that goes to the very heart and integrity of the criminal proceedings itself. There's a case called People versus Patterson in 1977, which talks about this, and they say the historical exception of the mode of proceedings error is made to ensure that criminal trials are conducted in accordance with the mode of procedures mandated by the Constitution and by statute, where the procedures adopted by the court below are at basic variance with the mandate of law. The entire trial is irreparably tainted, and it doesn't matter that it wasn't raised and preserved at trial. It can still be raised on appeal, and a conviction can be reversed on that basis if it's a mode of proceedings error. And the last thing you have to know in terms of background is that there's a section of law called Special District Attorney under County Law 701. And if a district attorney recuses him or herself for whatever reason, they can leave it to the court under 701 to find and appoint a special district attorney to basically be the prosecutor just for that one case. But the requirements for a special district attorney is that it has to be an attorney at law, having an office in or residing in the county or any adjoining county, to act as a special district attorney during the absence, inability, or disqualification of the district attorney and such assistance as he or she may have. And that person who's appointed by the court to be a special district attorney is, for all intents and purposes, district attorney for that matter. Okay? Okay. So what's the background? What are the facts in this case? The facts are that in this particular case, this takes place in Orleans County, which is a rural county in upstate New York. The defendant in this case was charged in Orleans County with various counts of larceny based on allegations that he improperly sold cars that were left to him to repair. So someone left cars for him to repair. He allegedly sold those cars instead of repairing them and kept the money from the sale. The Orleans district attorney recused himself, moved to be disqualified due to his relationship with the alleged victim in the case. The county court granted the application for the district attorney to be disqualified, to recuse himself, and appointed a special district attorney. The person he appointed in this case did not live in Orleans County or work in or live in the adjoining county, and didn't have an office in Orleans County or the adjoining county. Therefore, did not satisfy the requirements of County Law 701 as a special district attorney eligible for the appointment. But that person indicted the defendant, went to trial with the defendant, convicted the defendant, and there was never an objection made to that entire proceeding. Ultimately, the defendant then, after being convicted, appealed and said, hey, wait a second, the special district attorney in this case was not proper, was not qualified under County Law 701. And the response, the affirmation opposition to that appeal, the response was, well, you never preserved it. And so the question before the Court of Appeals is this the kind of error that has to be preserved as required generally by CPL 470.05, or is it a mode of proceedings error that, even though it's not preserved, can still be addressed and the basis of reversal? And ultimately, the Court of Appeals here decides that this is a mode of proceedings error. They say because a district attorney is an elected official, and because this goes to the basic elements of who that district attorney, special district attorney can be, and it's a separation of powers issue because a court is appointing the district attorney. And so you can't, ultimately they say this is not the kind of thing where you can just say it's a defect that can be waived. This goes to the very heart of the integrity of the proceedings. And because the special district attorney did not satisfy the requirements of 701 of the county law, his appointment was invalid as a matter of law. The defect goes to the very heart of the proceedings itself. And it's a non-waivable defect. It's motor proceedings error. Conviction is reversed. Indictment is dismissed. And that's the case of People versus Callara. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.